Good morning, everyone. This is the first captions test for YouTube. Microphone check, 1, 2, 3. Microphone check, 1, 2, 3.
Good morning, Commissioner Ginecca. Can you hear me?
I can hear you just fine. Can you hear me? I've got mic control.
Yes, sir. All good.
Looks like the webcam works as well. The background isn't
Yeah.
too obviously not a home office, is it?
All set. Thank you, sir.
Thanks.
Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, May 22nd, 2024. The time's 9:30 a.m. With us today are Commissioners Caterina Gonzalez, our General Counsel Mary Smith, and joining us virtually is Commissioner Bobby Ginecca, and I'm John Neerman. Registration is now closed, but if you'd like to address the Commission on a particular item, I'd invite you to visit our registration table or email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to comment on, and we will do our best to accommodate that request. For those addressing the Commission, our General Counsel or I will let you know when it's your turn and inform you of your time limits. I want to thank everybody for being present today, and Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the proposal for decision and proposed order concerning the application by the San Antonio Water System for water use permit 13098. The order of presentation will be the applicant, followed by the protestants collectively, the ED, and then OPIC. Each will have 5 minutes of oral argument time. The applicant may save time for rebuttal as it bears the burden of proof on this application. So we'll begin with the applicant. We have Mr. Jim Matthews. And I'd like to remind everybody to make sure the green light is on the microphone so that everyone can hear you online. Oh, I'm so sorry, 10 minutes for the applicant and for protestants collectively, 5 for ED and OPICs. Yep. Yeah.
Good morning,
and-
Ms. Oh, go ahead.
Oh, and is your light on your mic?
Yeah.
There we go.
Okay.
I'm hearing you. That's what I was going to say. Good morning, sir. Good to
Good
see
morning.
you.
Good morning, Chairman Neerman, Commissioner Gonzalez, and remotely to Commissioner Ginecca and the General Counsel Smith. I am Jimmy Matthews. I'm here appearing today on behalf of the San Antonio Water System, which I will refer to as SAWS or San Antonio. I'm joined today by my co-counsel, Ben Matthews, by SAWS Corporate Counsel, Jennifer Wincheffel, by SAWS Senior Resource Analyst, Greg Eckhart, and by SAWS Vice President for Legislative and Regulatory Affairs, Hope Wells. We appreciate the opportunity to present to you today. SAWS agrees with the findings of the PFD's finding that it met the requirements for issuance of its requested permit, but strongly disagrees with the PFD's recommendation that special conditions be added to protect protestants' lower basin water rights. The PFD's conclusion that protestants' appropriative water rights, which were granted to them in the 1940s and 1950s, were granted to them a second time through the water rights adjudication process is based on a misunderstanding of fundamental principles of Texas water law. The special conditions requested by the protestants would defeat one of SAW's primary objectives for its application, which is to make a voluntary contribution of at least 50,000 acre feet of its currently surplus, privately owned groundwater-based return flows to assist in maintaining the biological soundness of the Texas rivers, lakes, bays, and estuaries. It's consistent with state policy as reflected in Water Code 11.0235. It's also consistent with protecting fisheries and coastal economic interests. There are 2 separate and independent lines of proof in the record evidence that demonstrate that protestants' water rights were not granted based on SAWS return flows and thus not entitled to protection under 11042B. First, the record contains a rational and comprehensive explanation of the ED's 2-step analysis that has been consistently applied to all 11042B applications granted since the Commission's 2006 order in the Bryan case. The record describes that 2-step analysis in detail and it explains how it was applied to SAW's application. The Executive Director's 2-step analysis is not time sensitive. It is valid regardless of whether the protestants' rights were granted to them in the 40s or 50s or decades later. The ED concluded that the protestants' water rights were not granted based on the use or availability of SAWS return flows, primarily because her water availability model analysis showed no significant change in the volume reliability of those water rights with and without SAWS return flows. The PFD concludes that the executive director's WAM analysis, and I'm quoting, may be reasonable for staff's initial analysis of the application, but thereafter it fails to consider the ED's position in reaching its ultimate conclusion that protestants rights were granted to them a second time through the water rights adjudication process. Secondly, the record shows that in 1951, the Board of Water Engineers granted appropriate water rights specifically for San Antonio's effluent discharge into the river, granted that right to 2 individuals who had purchased the effluent from the city. Subsequently, in 1952, the protestants applied for a water right and obtained a water right for 127,000 acre feet needed to support their planned chemical plant in Calhoun County. That water right was granted based on a study submitted to the Board of Water Engineers by UCC that determined that Saul's effluent would not be available for their water right because the effluent had already been appropriated through another water right. Studies showed that even without Saul's effluent, UCC's water right would be 98% reliable, which it deemed to be an adequate supply for the project. Additionally, due to Texas' long-standing prohibition on double permitting of appropriate water rights, Saul's effluent could not have been appropriated by the Board of Water Engineers to these other parties in 1951 if that effluent had been the basis for granting protestants lower basin water rights with earlier priority dates. The PFD acknowledges that San Antonio's discharge effluent was appropriated to other parties until it was canceled. Protestants' appropriate rights were granted to them a second time, but it leaps to the conclusion that protestants' appropriate rights were granted to them a second time after their appropriation in the 40s and 50s through the Water Rights Adjudication Act. The PFD's conclusion is unprecedented, erroneous, and contrary to Texas statutes governing the granting of appropriate water rights and the Water Rights Adjudication Act. The Water Rights Adjudication Act created a procedure for recognizing claims to existing water rights, but not the second granting appropriate water rights. The Water Rights Adjudication Act lacked essential elements required for the granting of an appropriate water right under Texas law. It required no analysis of water available for appropriation. It required no determination of the impact of an alleged new appropriation on existing water rights. The PFD's conclusion is also contrary to the record evidence from protestants' own witnesses who admitted that the act prohibited recognizing any water right that did not exist before its effective date. The act did not grant protestants appropriate rights they did not previously have. The priority date assigned in protestants' certificates of adjudication is based on the date of the application for the underlying water right granted in the 40s and 50s. It simply was a certificate of adjudication is simply not the grant of a new water right. It cannot serve as a basis for providing protection under 11042B. SAWS requests that you adopt its recommended changes to the findings of fact and conclusions of law and approve issuance of the draft permit without changes recommended by the PFD. I'll be glad to answer any question and reserve my remaining time for rebuttal.
Thank you, Mr. Matthews. I have none at this point. Commissioner Chineka, any questions? Shaking his head, no. Commissioner Gonzalez? No. Thank you, sir.
Ms. Samia Broadway for the protestants.
Good morning, Ms. Broadway.
Good morning, Chairman. With your indulgence, we're just going to put up a demonstrative. It's the statute.
And Commissioner Chineka, you may be able to see this on your screen. If not, it is it's an exhibit showing the language of Water Code Section 11.042B.
Good morning, Chairman Neerman, Commissioner Gonzalez, Commissioner Ginecca remotely, General Counsel. My name is Samia Broadway. I'm here on behalf of the protestants in this case. I represent the Guadalupe Blanco River Authority, or GBRA. With me here today is my co-counsel, Molly Cagle, as well as distinguished guests from GBRA, Director Cyrier from our Board of Directors, and Mr. Daryl Nichols, the General Manager, CEO of the GBRA. I'm also here before you on behalf of the other protesting party, Union Carbide Corporation, or UCC. I know you've received sign-in sheets from UCC supporters who are here in the audience today, and we appreciate their support. GBRA and UCC support the ALJ's proper conclusion that if this commission grants SAWS's requested authorization, special conditions are necessary to protect GBRA and UCC's water rights. Together, GBRA and UCC jointly hold some of the most senior and most significant water rights in this basin. GBRA supplies water across a 10-county district from Hays and Comal and Caldwell counties all the way to Calhoun County. UCC has a chemical plant down in Seadrift, Texas that employs over 1,200 people. The ALJs in this case correctly found that even a 1% reduction, not a 5% reduction, but a 1% reduction in the current reliability of GBRA and UCC's water rights would have real harm to these surface water rights holders. And the record shows that in times of drought, in a repeat of the drought of record, that impact of SAWS's application could be over 30% reduction in the current reliability of GBRA and UCC's water rights. That means that there would be at least 1 month during a repeat of the drought of record when GBRA would be unable to divert for municipal supplies. UCC would eventually have to shut its chemical plant at a cost of $1 million a day. That's real impact, not only on GBRA and UCC as water rights holders, but also on the people and industries that rely on GBRA as their water supplier to provide them with water each and every day. The executive director's 95% rule of thumb ignores this reality. The ALJs got this case right. They got this case right when they found that special conditions are necessary to protect GBRA and UCC's existing water rights, and that SAWS's accounting plan must be corrected. SAWS's accounting plan issues have been well documented in the briefing. The key is that SAWS failed to address the conveyance losses across the entirety of their conveyance from discharge to diversion, and they must do that. Unless you have any questions, I'm not going to address the accounting plan further today. Instead, I'll focus on the special conditions. First, looking at the statutory language, 11042B, and the record, it is clear that special conditions are required to protect GBRA and UCC's water rights. Second, protecting those water rights by special condition is entirely consistent with past commission practice as well as the statute. And finally, the record supports at least 3 different special conditions that would protect GBRA and UCC's water rights. We submit that the most straightforward of those conditions that is supported by the record is the imposition of a priority date of May 9th, 2016, which is the date that the executive director declared SAWS's application administratively complete. That condition coupled would protect GBRA and UCC. 11042B was a legislative compromise designed to allow some reuse while protecting downstream surface water rights. This statute is an exception to the default rule of Texas water law that water placed into a water course is state water and subject to prior appropriation. The ALJs correctly found that the existing water rights that are referenced in 11042B are the certificates of adjudication held by GBRA and UCC. Those certificates of adjudication on their face superseded all prior rights of the parties as they went through the adjudication. SAWS's position depends on a hyper-technical reading of the word granted that, if true, would eliminate the possibility that an existing water right could ever be granted based on use, completely reading that option out of the statute. But even if this commission disagrees with the ALJs and determines that those underlying permits are the existing water rights referenced in 11042B, the record also shows that GBRA and UCC's water rights require special condition protection because those underlying permits too were granted either on the availability or the use of return flows in the 1940s and 1950s. Turning now to the prior decisions of this commission, there are three that the executive director and SAWS have cited, and the ALJ's recommendation in this case is entirely consistent with all of them. First, the City of Bryan interim order, then the City of Lubbock, and finally, the BRA system operations permit. All three cases arose in the Brazos River Basin, but none directly addresses the case before you today. The City of Bryan interim order, I'll take chronologically, speaks to the contents of an 11042B application. What has to be in an application for 11042B authorization? And it says in evaluating those contents of that application, look only to the statute and its implementing rules. Don't look further into Chapter 11. And that's what we're doing here today. The City of Bryan interim order does not address which existing water rights to protect, how to identify them, or how to protect them by special condition. The ALJs made that determination in this case consistently with the City of Bryan interim order. Moving now to the City of Lubbock and the BRA system operations permit. These are two decisions that have to do with the chronology of the wastewater discharge relative to the existing water right that could be protected by the statute. The City of Lubbock had to do with a new groundwater-based effluent discharge to the watercourse that started in 2003. Decades prior, Jane's Gravel had received a water right. So of course that water right could not have been granted based either on the use or availability of the return flows that were not yet in the river. But that's not the case in this situation. San Antonio's effluent has been in the watercourse since at least the 1930s, as reflected by this record, and GBRA and UCC's water rights were issued immediately after in the 1940s and 50s. The discharges and the water rights in this case have coexisted for decades, and decades prior to the 11042B statute that we're discussing today. Turning now to the BRA system operations permit, chronology is also important there. That had to do with a new water right, a new appropriation that was given by this commission to BRA for state water that included effluent discharged by other people into the watercourse. BRA asked for an appropriation, the commission said yes, but if an existing discharger came in for an 11042 authorization, the commission said BRA could not claim to be an existing water right that was granted based either on the use or availability of those return flows. Again, very different from the situation we have here today. The ALJ's recommendation is consistent with all the decisions that the executive director cites as precedent. And given the ALJ's recommendation that special conditions are required to protect GBRA and UCC's water rights, come to the question of what special conditions are necessary. And the record supports at least three. One is the imposition of a priority date. May 9th, 2016, the date that SAWS's application was declared administratively complete, would be appropriate and supported by the record. Alternatively, a limited subordination of San Antonio's right to divert this water under an 11042B authorization to GBRA and UCC's existing water rights, effectively giving SAWS a priority date, one date junior as to GBRA and UCC, would allow in times of drought, GBRA and UCC to take under their senior surface water rights before SAWS takes under their 11042B authorization. Third, a volume-based limitation on GBRA and UCC's right to divert as a special condition would also be protective. The record shows that during the look-back period of the adjudication, that 10-year period, SAWS's effluent was in the river and flowing 200 miles downstream to the source of supply for GBRA and UCC's water rights. And the volume was approximately 84,000 acre feet in 1981. Protection of that volume for GBRA and UCC, coupled with the right accounting, could also be protective of GBRA and UCC's water rights, and the record supports this. All of these options, though, would need to be coupled with notice and future opportunity for GBRA and UCC to contest any amendment of this authorization to ensure that the special conditions endure and remain protective. If this commission grants SAWS its requested authorization, the statute requires that GBRA and UCC be protected with special conditions. We support the ALJ's analysis and urge the Commission to impose a priority date of May 9th, 2016 on this authorization. I'm happy to answer any questions now, but if you have other questions after listening to the other parties that I might be able to help address, I'd be delighted to come back and address you at that point. Thank you.
Thank you, Ms. Broadway. Excuse me. I have none. Commissioner Janetka, any questions?
No, thank
Seeing
you.
none. Commissioner Gonzalez? Thank you, Ms. Broadway.
Thank you.
Appreciate it. Good morning.
Good morning, Mr. Chairman, Commissioner Gonzalez, Commissioner Janetka. My name is Ruth Takita. I'm an attorney with the Environmental Law Division here at the agency and represent the Executive Director, or ED. With me is Dr. Kathy Alexander from the Water Availability Division. Water rights applications can be complex and complicated because the law governing these applications is subject to different interpretations. The ED believes this application is straightforward. It is a request for authorization to transport groundwater-based return flows from specific points of discharge for downstream beneficial reuse pursuant to Texas Water Code Section 11.042B. ED program staff reviewed this application, analyzed it under applicable requirements, concluded that it met requirements, and prepared a draft permit. Every aspect of staff's review was appropriate because it was consistent with long-standing program practices and procedures and commission precedent in other applications seeking the same authorization. The protestants argue that their water rights are entitled to special protection because they assert that their rights were granted based on the use or availability of the applicant's return flows. The ED disagrees because her analysis shows that only the applicant owns water rights explicitly granted based on these return flows. Other water rights, including the protestants, were not granted based on either the use or availability of these return flows because a mere presence of historic effluent in a watercourse does not demonstrate that a water right was granted based on the use or availability of return flows in the context of an 11.042B application. Therefore, the ED respectfully disagrees with the ALJ's findings that the protestants' water rights were so granted and that they are entitled to special protection. The bases for the ED's position on these issues and more are addressed in the ED's closing argument and her PFD exception and replies, especially as to the special conditions proposed. Those can be found in the ED replies. The ED recommends that the application be granted because the San Antonio water system carried the burden of proof imposed by the ALJs in this proceeding and met all applicable requirements for issuance of the permit as drafted by the ED. We are available for questions and we thank you.
Thank you, Ms. Takeda. I have none. Commissioner Janetka? Seeing none. Commissioner Gonzalez? No questions. Thank you. Good morning, Mr. Martinez.
Good morning, Chairman, Commissioners Gonzalez and Janetka.
I'm not sure I'm hearing you. Is your light turned on?
It's turned on. Maybe I'm not close
Maybe
enough.
pull it
Is that a little
closer.
better?
Yeah.
Okay.
Thank you.
Sure. General Counsel and Executive Director, my name is Eli Martinez, and I'm with the Office of Public Interest Counsel for the record. We participated in this hearing and have reviewed the evidence and briefings submitted by all parties. Our closing arguments indicated our position that the applicant had generally met its burden for issuance of water use permit 13098. However, we recommended that the accounting plan be modified before issuance to incorporate carriage losses for the entire conveyance reach as well as travel times throughout that reach. We did not feel that special conditions were necessary to protect the protestants due to our analysis of their original water rights, which did not contain specific language indicating that the applicant's return flows were relied upon to determine that sufficient supply was available, in addition to the issues of double appropriation raised by the applicant and the modeling conducted at the time of issuance of those rights and subsequently repeated and confirmed by the executive director, showing a minimal amount of impact to their reliability in the absence of SAWS discharges. We found that these were indicia that the protestants' water rights were not issued in reliance upon SAWS return flows. However, the PFD has found that the protestants' use of SAWS discharges during the look-back period analyzed in their certificate of adjudication proceedings conveyed the type of authorizations that are entitled to protection under 11042B. This finding compels us to expand and evolve our analysis to consider whether the PFD's ensuing conclusions with respect to special conditions would be appropriate under that assumption. And we found that if the commission does indeed accept that the PFD's premise that the active water rights referred to in 11042B do include the certificates of adjudication held by the protestants, special conditions are indeed required to protect those rights. This conclusion is based upon the final determination of the adjudication that the state waters subject to the adjudication comprise all flows of the various streams in the lower Guadalupe River segment, coupled with the fact that SAW's discharge records established that the discharges began at the latest in 1940 and continued throughout the look-back period. Therefore, the certificates of adjudication were based upon the use of SAW's return flows, which at that time were legally commingled state waters no longer under contract. Further, the protestants' rights could be impacted by the proposed permit during drought conditions such that some of their water rights that were previously 100% reliable would become interruptible and even reduce the volume reliability for protestants' previously firm municipal components by 25 to 35% during a year matching the drought of record, at least under certain time steps. Therefore, special conditions are necessary to effectuate protections over those rights. To conclude, we found that the applicant has generally met their burden with respect to water use permit 13098, but recommend that the commission require that the accounting plan be modified to incorporate carriage losses and travel times, and that should the commission determine that the protestant certificates of adjudication are contemplated under 11042B, special conditions must be included to protect those rights. Thank you. I'm available for any questions.
Thank you, Mr. Martinez. I have none. Commissioner Ginecca, any questions? Commissioner Gonzalez. All right, Mr. Matthews, you have 3 minutes for rebuttal.
Ms. Broadway mentioned three precedents, Bryan, BRA, and Lubbock, and she herself distinguished the BRA and Lubbock from this case. The Bryan is perhaps the best analogy. Bryan's application was based on discharges that commenced in 1948. The record evidence in this case shows that there were 62 appropriate water rights issued downstream of Bryan following the commencement of its discharge. Only one of those 62 water rights got protected via the Bed and Banks authorization. And that one right said that the permittee could only divert when Bryan was discharging from its wastewater plant. The connection between the discharge and the diversion was clear. Protestants also make the argument that the mere presence of water in the stream constitutes the basis for the granting of the permit. The language of the statute is clear. What is really important in 11042 is, was the water right granted based on the use or availability? So it's the basis for the granting of the water right that is important. The PFD cites at the beginning of its analysis on whether the water rights were granted, the following quote. This came from the OPIC's brief. The administrative process responsible for drafting permit language has historically been inconsistent, rendering the practice by which water rights have been processed, considered, and written over previous decades as neither unvaryingly uniform nor comprehensively articulated. In other words, you can't simply say that the fact that the water is being discharged means it was the basis for granting a permit. In order to prove that your water right was granted based on an applicant's discharge, you have to go into the water right itself and look at the basis for its granting. We did that with the water right granted to Union Carbide in 1952. Their own evidence submitted to the Board of Water Engineers said, we've got a water study and we're not relying on Saul's effluent. Not every case is going to have the luxury of having that. That's why you need to go back to the executive director's methodology, which is an analytical methodology that looks at every water right in the basin to determine whether or not it has language indicating it was granted based on another water right, and goes through a water availability analysis that was rationally explained. And it looks at the change in the volume reliability of that water right over a long-term period of time, consistent with the basis on which the water rights are granted. These water rights held by Carbide and others are not granted on a daily, weekly, or monthly basis. They're granted on an annual basis. And so all of their analyses that purport to look at this on a daily, weekly, or an annual basis is an artificial manipulation of what the water right is.
That's time.
Thank you.
Thank you, Mr. Matthews.
Okay.
Colleagues, any questions for any of the parties? Commissioner Ginecca? Commissioner Gonzalez, seeing none? Okay. Colleagues, I agree with the ALJs that this permit should be issued. I also agree that the accounting plan should be updated. I disagree that special conditions should be added related to the protestants' water rights. Water Code Section 11.042B requires us to protect any water rights that were granted based on the use or availability of the groundwater-based return flows. We've heard quite a bit of argument around that statutory language this morning. This requires us to be clear about when the rights were granted. And I believe that the ALJs misconstrue the effect of the adjudication process, concluding incorrectly that the protestants' water rights were granted based on the use or availability of SAW's groundwater-based return flows during the adjudication period. In fact, the adjudication did not fundamentally change the protestants' rights, which were granted well before the adjudication process. So we must look at the use or availability of groundwater-based return flows at that earlier time. And in my view, the evidence demonstrates that the issuance of these permits was not based on the use or availability of return flows from San Antonio's wastewater discharge. And Ms. Broadway is absolutely correct when she says that the discharge and the rights coexisted during this time frame. And so we have a legal question. What does based on mean in the statute? And I think, while I don't dispute the facts, my legal conclusion is that based on means a legal right. And so let me be specific about the evidence that I'm looking at in the record, and that is the 1951 Bancroft-Kelly permit that's been referenced today, which committed all of San Antonio's groundwater-based return flows. Permits that were issued to protestants before the Bancroft-Kelly permit could not have been based on return flows. For that permit, that Kelly-Bancroft permit, would have been issued in error. They could not have issued the Bancroft-Kelly permit based on return flows that were already claimed. Permits issued after could not have been based on the return flows either, as these flows were already committed to Bancroft and Kelly. So colleagues, that in a nutshell is my view. I am not inclined to add, in fact, I would not recommend adding any special conditions. And that's my take. Commissioner Ginecca, what are your thoughts?
I'm in agreement. I think the executive director's draft permit should be issued. And I also don't think that special conditions are necessary to protect protestants' water rights, because those water rights were not based on the use or availability of SAW's groundwater-based return flows. I think the ED's methodology appropriately looked at the special conditions and protestants' water rights to see whether they were based on the use or availability of SAW's groundwater-based return flows. Based on SAW's discharges today, I think the second step of the ED's analysis does demonstrate that there may be limited impacts to protestants' water rights, but the fact that protestants' water rights might be impacted does not demonstrate that they were granted based on the use or availability of SAW's groundwater-based return flows in the 1940s and 50s. I do appreciate as well the point you make about the 1951 Bancroft case, and am firmly in agreement about that evidence featuring prominently in my analysis. Thank you.
Thank you, Commissioner. Commissioner Gonzalez?
After reviewing the PFD and the record, I agree with the ALJs that the draft permit should be issued, but I don't think that additional special conditions are necessary to protect protestants' water rights. My concern with the ALJ's analysis is that they base their review on the look-back period during the adjudication process. In my mind, it's more appropriate to look at whether protestants' water rights, which were issued in the 1940s and 1950s, were based on the use or availability of SAW's groundwater-based return flows at that time. I don't think that because SAW's discharges began before protestants' water rights were granted, they were dependent on the availability of SAW's groundwater-based effluent. Not all of the water in the watercourse is from SAW's groundwater-based return flows. It's also made up of different sources, including rainfall, spring flow, and other wastewater discharges. We also have to keep in mind that in the 1940s and 50s, before the Water Rights Adjudication Act, there were riparian users that were not statutorily regulated. For me, the ED's use of two-step methodology in the issuance of the Bancroft permit, which authorized the use of up to 40,000 acre-feet of San Antonio's effluent, indicates that protestants' water rights were not granted based on the use or availability of SAW's groundwater-based effluent. I also don't think there's a legal basis in Texas Water Code 11.042B to reach the issue of whether special conditions are necessary unless there's a finding that protestants' water rights were granted based on the use or availability of SAW's groundwater-based effluent. An 11.042B permit is a permit to convey privately owned groundwater-based return flows in a water course. Consistent with the City of Bryan and City of College Station interim order and the Day case, this type of authorization is not an appropriation of state water. Groundwater is private property, and as the Day case confirmed, it retains that character when it's discharged into a state water course under Texas Water Code 11.042B. A 297.45 no impact analysis, which is used for the appropriation of state water, is not required under Texas Water Code 11.042B. Since protestants' water rights were not granted based on the use or availability of SAW's groundwater-based return flows, I do not believe there's a need to add special conditions to the ED's draft permit.
Thank you, Commissioner. Colleagues, it seems like our analysis is generally in alignment, at least with respect to the result that we seem to be in favor of granting the permit without special conditions. What I might do, and this is becoming a familiar practice, I prepared a document that explains in a little bit more detail the rationale that I highlighted a few moments ago. It details the specific changes that I would make to the findings of fact and conclusions of law and ordering provisions. So I'll propose to share that with you and with the parties, and the three of us can take a brief recess to digest that, and we'll come back for conversation to see if there's see if you're on board with it or have any concerns or questions at that point. If that works for you, any other thoughts before we do so? Okay. All right, I've got 10:07. Why don't we break until 10:15, and then if we need more time after that, we can allow more time. So the time is 10:07, and we are in recess. Commissioner Janeka, do you need more time to review this? You're good?
Thank you. I'm ready.
We have a minute. Time is 10:15. We're back. Sorting out a technical issue. Bear with us momentarily. Good. Okay. Commissioner Janeka, your thoughts?
I've reviewed that red line version and don't have any questions or concerns with it. I'm prepared to vote in support of that today.
Commissioner Gonzalez.
I reviewed the document as well, and I don't have concerns as well.
All right, well, I'll go ahead and offer a motion then. Colleagues, I move that we adopt the ALJ's proposed order in accordance with my remarks today and the document that I circulated titled Recommended Changes for SAWS Water Use Permit number 13098. Further move that we issue water use permit number 13098 to the San Antonio Water System as recommended by the Executive Director, but order the Executive Director to incorporate the Kennedy Memo, SAWS Exhibit 14, into the accounting plan to account for travel time and losses, if any, between the saltwater barrier and the diversion reach. And that's the end of my motion.
I'll second it.
The motion has been made and seconded. All those in favor say aye.
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 Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
I'm just going to give everybody some time to get out of the room before I call the next one. Item number 2 is the consideration of an application by Vale Building Group LLC for new TIPD's permit number WQ00162120001. The parties have been notified that the commissioners will not take oral argument, but may ask questions.
So colleagues, Jonah Water Special Utility District has requested a hearing based on its concerns about its drinking water well, among other issues that are within our jurisdiction on a TIPD's application. District's well is within 100 feet of the proposed discharge route, and in its existence demonstrates an interest that's different from the general public. So I would grant the district's request on the following issues: whether the draft permit is protective of water quality, including the prevention of excess algal growth, whether it meets the distance requirements with respect to water wells, and whether the permit should be altered or denied based on regionalization. I would allow 180 days and include an ADR referral. Commissioner Janeka.
I would be supportive of that finding as well.
Commissioner Gonzalez.
Also supportive.
I think we're ready for a motion.
I move that we grant the hearing request of Jonah Water Special Utility District, that we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit is adequately protective of water quality, including the prevention of excessive algal growth in accordance with applicable regulations, including the Texas Surface Water Quality Standards. B, whether the draft permit complies with 30 Texas Administrative Code 309.13, including compliance with distance requirements of wastewater treatment units in relation to water wells. And C, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of wastewater regionalization under Texas Water Code 26.0282 and 26.081. I further move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process. And finally, move that we set a hearing duration of 180 days from the date of the preliminary hearing until a proposal for decision is issued.
Second.
The motion has been made and seconded. All those in favor say aye.
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 Aye. Motion carries. Ms. Smith, please call the next item.
Item number 3 is the consideration of the application by LGI Homes Texas LLC for new TIPD's permit number WQ001-627-5001. The parties have been notified that the commissioners will not take oral argument, but may ask questions. And I'll remind the commission that yesterday the hearing requesters withdrew their hearing request, leaving only the request for reconsideration for the commission's review this morning.
Thank you, Ms. Smith. Colleagues, as Ms. Smith just noted, we do not have a pending hearing request. The pending request for reconsideration, in my mind, in my view, does not provide any new information to call the executive director's valuation into question. So I would deny that request. Commissioner Ginecca?
I agree.
I also agree.
Ready for a motion?
I move that we deny the request for reconsideration, grant the application by LGI Homes Texas LLC for their TIPD's permit number WQ001-627-5001, issue the draft permit as recommended by the executive director, and adopt the executive director's response to comment.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 Motion carries. Ms. Smith, please call the next item.
Item number 4 is the consideration of the application by the Psalm 2510 Foundation for the new TIPD's permit number WQ001-6202001. The parties have been notified that the commissioners will not take oral argument, but may ask questions.
So we have 5 hearing requests on this item. I would grant the requests of Brennan Massingale and Richard Moore. Both live on the discharge route within approximately 1.25 miles of the outfall, and they raise personal justiciable interests that were stated both in timely comments and their timely hearing requests. I believe we are required to deny the remaining requests. Mr. Guthrie did not preserve his issues in his comments. Mr. Hess does not explain how he would be affected in a manner different from the general public, and the Wests, together with their family trust, submitted no comments. Let me pause there and check in with you, Commissioner Ginecca.
I found the same parties to be affected.
Commissioner Gonzalez?
I'm in agreement.
Okay, turning to the issues, I would refer the following. Whether the draft permit is protective of water quality, whether it is protective of the requester's health, whether it is protective of livestock, wildlife, and aquatic life, whether it properly classifies the aquatic life uses, whether notice requirements were met, and whether the commission should alter or deny the permit based on the consideration of need. I would also include an ADR referral and allow 180 days for the PFD. And I would also note that we had several requests for reconsideration, which I would deny because they raise the same issues that we would refer to SOA. Commissioner Ginecca.
I identified the same items and am in agreement with the other aspects of the motion.
Also in agreement.
Okay, I think we're ready for a motion.
I move that we grant the hearing requests of Richard Moore and Brennan Massingale, that we deny the remaining requests for hearing and all requests for reconsideration, that we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit is adequately protective of surface and groundwater quality, including evaluation of anti-degradation, nutrient screening, aesthetic parameters, and the use and enjoyment of property in accordance with the Texas Surface Water Quality Standards. B, whether the applicant substantially complied with applicable notice requirements. C, whether the draft permit is adequately protective of the requester's health, wildlife, livestock, and aquatic life. D, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code 26.0282, and E, whether the draft permit properly classifies the aquatic life uses in the discharge route in accordance with the Texas Surface Water Quality Standards. I further move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts and set a hearing duration of 180 days from the date of the preliminary hearing until a proposal for decision is issued.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Ms. Smith, when you're ready, I'll ask you to, the motion carries unanimously. Commissioner Janeka's audio was a little bit compromised on that, but I heard him and saw his lips move saying aye. So thank you. So again, the motion carries, and Ms. Smith, I'll ask you to go ahead and call the next item.
Item number 5 is the consideration of the application by Mind Service, Inc. for issuance of air quality permit number 169683 to authorize a rock crushing and screening plant. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Colleagues, I would grant both requests on this item. David Lutke and Cindy Lutke live within approximately a half mile of the proposed facility and both express concerns about air quality. Mr. Lutke is more specific in his concerns about health effects, but I believe both expressed a personal justiciable interest different from the general public. So I would refer their requests with the following issues: whether the draft permit protects air quality, whether it protects the health and safety of the requesters, and whether it adequately protects against nuisance dust. And again, I would include an ADR referral and allow 180 days. Commissioner Janeka.
I agree.
Commissioner Gonzalez,
Also agree.
do we have a motion?
I move that we grant the hearing request of David and Cindy Lutke, refer the application to SOA for a contested case hearing on the following issues. 1, whether the draft permits provisions adequately protect air quality. 2, whether the draft permits provisions adequately protect the health and safety of the requesters. And 3, whether the draft permits provisions adequately protect against nuisance dust conditions. So move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process and set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 Aye. The motion carries. Ms. Smith, please call the next item.
Item number 6 is the consideration for the adoption of one total maximum daily load for indicator bacteria in Cotton Bayou Tidal. The executive director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Nicole Hall with the Water Quality Planning Division in the Office of Water. With me virtually today are Wyatt Eason with the Total Maximum Daily Load Program and Aubrey Pawelka with the Environmental Law Division. Today, the Executive Director is requesting the consideration for final adoption of one total maximum daily load for indicator bacteria in Cotton Bayou Tidal. The TMDL covers one assessment unit and one water body within Chambers County. A stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the TMDL document. The development of this document included an active public participation effort and balanced stakeholder group coordinated by TCEQ and the Houston-Galveston Area Council. The success of this project is due to the collaborative efforts of the individuals and organizations that put in the time to develop this document to improve water quality in their community. The Executive Director respectfully requests the adoption of the total maximum daily load. Permission is also requested to make non-substantive and clerical corrections if needed. Thank you, and we are available to answer any questions that you have.
Thank you, Ms. Hall. I have none. Colleagues, any questions? Seeing none, Ms. Smith, is anyone signed in to speak?
No one is registered on this item.
Thank you. Mr. Arthur, what's the view from the Office of the Public Interest Council?
Good morning, Chairman, and good morning, Commissioners. After review of this TMDL, including the public comment from Thomas Carroll and the ED's response, OPIC supports adoption.
Thank you. Well, colleagues, first I want to say we very much appreciate the support of the Houston-Galveston Area Council in this effort. We appreciate our stakeholders who participated in this plan, and as always, our outstanding TCEQ staff. I am pending your thoughts, ready to move forward with adoption. Commissioner Ginecka?
Thank you, Chairman. I'm in agreement as well, and I likewise want to thank and appreciate the staff's efforts surveying this detailed and comprehensive broad lift effort. I'm prepared to move forward as well.
Thank you. Commissioner Gonzalez?
I agree.
We're ready for a motion.
I move that we adopt one total maximum daily load for indicator bacteria in Cotton Bayou tidal of the Trinity River Basin in Chambers County, as recommended by the Executive Director.
Second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 7 is the consideration for adoption of 2 total maximum daily loads for indicator bacteria in Chocolate Bayou of the San Jacinto Brazos Coastal Basin. The Executive Director's staff is here to present this item.
Good morning again.
Good morning. For the record, I am Nicole Hall with the Water Quality Planning Division in the Office of Water. With me virtually today are Wyatt Eason with the Total Maximum Daily Load Program and Aubrey Pawelka with the Environmental Law Division. Today, the Executive Director is requesting the consideration for final adoption of 2 total maximum daily loads for indicator bacteria in Chocolate Bayou. The TMDLs cover 2 assessment units and 2 water bodies within Brazoria and Fort Bend counties. A stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the TMDL document. The development of this document included an active public participation effort and balanced stakeholder group coordinated by TCEQ and the Houston-Galveston Area Council. The success of this project is due to the collaborative efforts of the individuals and organizations that put in the time to develop this document to improve water quality in their community. The Executive Director respectfully requests the adoption of the total maximum daily loads. Permission is also requested to make non-substantive and clerical corrections if needed. Thank you, and we are available to answer any questions that you have.
Thank you, Ms. Hall. Colleagues, any questions for Ms. Hall? Seeing none, has anybody signed in to speak?
No one is signed in to speak.
Mr. Arthur?
After review of this TMDL, including the public comment from Dick Tyson and the ED's response, OPIC supports adoption.
Thank you. Colleagues, I do as well. Again, thanks to the Houston-Galveston Area Council, our stakeholders who participated in this process, and our staff. I am ready to adopt.
I move that we adopt 2 total maximum daily loads for indicator bacteria in Chocolate Bayou of the San Jacinto Brazos Coastal Bend in Brazoria and Fort Bend counties, as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to the enforcement docket, which are items 8 through 28, and the Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 8 through 28. The total assessed administrative penalties are $471,323, with $102,221 deferred, $146,345 applied towards supplemental environmental projects, and $222,000 $12,757 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. Colleagues, any questions for Ms. Cordell? All right, seeing none. Ms. Smith, has anybody signed in to speak on this item?
On items 17 and 18, we have individuals who have signed in and indicated that they're available for questions if the commission has questions. And then on item 9, we have some people signed in that would like to address the commission. And I would just like to remind everyone to allow enough time for all who wish to be heard during this meeting. The commission limits initial comments from each speaker to 3 minutes and extends that time if the commission has would like further discussion with that speaker. So we'll begin with Michael Bates for Joppa Freedmen's Town Association.
Good morning, Mr. Bates. Are you there?
Yes, are you able to hear me?
Not quite. Try it again.
Are you able to hear me?
Now we do loud and clear. Go ahead when you're ready, Mr. Bates.
Fantastic. Are we limited to having one party speak, or will both myself and my co-counsel Wendy Hammond have time to speak?
I'll let our general counsel take that. You may both take 3 minutes.
Wonderful. I would like to request that Wendy Hammond, since she's in person, that she's able to speak first if feasible.
Absolutely.
Fantastic.
Hammond? Good morning. Podium's there, and when you get up there, I'll ask you to check your mic and make sure that the light is on.
The light is on. Can you hear me?
Great, I can. And go ahead when you're ready.
All right. Hello, thank you. My name is Wendy Hammond. I am a staff attorney with Legal Aid of Northwest Texas, representing the Joppa Freedmen's Town Association, which the Joppa is a historical freedmen's town that is inundated and surrounded by industry on all sides of the small community. They're basically landlocked by facilities. They are located just north of this facility. And Joppa has been active in this actual proceeding as well as the permitting that is supposed to be going forward. Rather than going directly and reiterating what we've already submitted to the commissioner, I just wanted to point out a few things regarding the executive committee's, the executive summary, just to clarify some points and to ask some questions. Because we're very concerned about the penalty assessment in this case because it's very low considering this facility is operated for years. The penalty assessment is apparently only assessed from September 12th, 2022, but the executive summary even acknowledges elsewhere that they are aware that Texas Star Ready Mix took over the lease on January 14th, 2021. And yet TCEQ staff refused to obtain the operational logs from the facility to determine exactly just how long they truly have been operating without proper authorization. They also refused to provide those documents in response to a Public Information Act so that the Joppa Freedmen's Town Association could meaningfully participate in not only this enforcement action, but also within the subsequent standard permit authorizations they are trying to obtain. The other issue is culpability. Basically, the Texas Star Ready Mix knew or should have known that after the first facility investigation that it was improperly operating. Yet it continued to operate even after being investigated by both the City of Dallas and TCEQ and repeated public outrage and outcry. They continued to operate and even admitted to operating 10 to 15 trucks per day during the public meeting on their standard permit authorization. Joppa has provided these types of facts and other new facts that allow the commission to withhold the authorization of this agreed order, to go back to find out what is the proper penalty that should be assessed for this egregious behavior. This community is looking towards this agency to be able to solve the problems that it faces. The thing is that we all know environmental laws are set up like a three-legged stool. You have your federal, you have your state, and you have your public. And if one of them fails, the laws don't work and they don't protect the public. Joppa understands that the state's resources are limited. Staff's time is limited. That is why they are actively participating and requesting that you deny this agreed
That's
order.
3 minutes.
I'll ask
Thank
you
you
to
very
finish your thought, Ms. Hammond.
To deny this agreed order, and I will allow my co-counsel to complete his 3 minutes.
Okay.
Thank you.
Thank you, Ms. Hammond. Mr. Bates? Go ahead when you're ready, sir.
Wonderful, thank you. Yes, so my name is Michael Bates. I'm also a staff attorney with Legal Aid of Northwest Texas, and I also represent Joppy Freedmen's Town Association. To expound on what my co-counsel was discussing, it's our belief that without TCEQ gathering these operational records and refusing to do so, and then also refusing to share them, that this failure to include this type of evidence means that there was an improper assessment of this penalty. Under Texas Water Code 7.053, the factors need to be assessed in order to create a proper enforcement penalty. Just to highlight a few of these include the hazards created for health and safety of the public, the impact of continuing violations on the air quality of the region, respondents' history and extent of previous violations, respondents' economic benefit gained through violations, and the penalty's ability to deter future violations. Without this type of information and the agency's refusal to gather it, it's our understanding that Joppy cannot be protected through this type of enforcement record. And the commission has the ability to look at these type of new facts. The new facts include that the representatives of JFTA witnessed on multiple occasions respondent operating during this period of time. Those types of evaluations were not included in this penalty assessment. If you look specifically at the penalty assessment, it was a mere guess as to when they were operating, and a low number of operations were included per week or per month compared to what respondent admitted to of operating 10 to 15 trucks a day. Furthermore, respondent claimed a financial inability to pay regarding their fine. However, Joppy was not given the right to review these financial inability to pay documents. Failure to provide these documents has a significant and detrimental impact on Joppy and the public. Without documentation of respondents' inability to pay assessed penalties penalties imposed on the facility's illegal operation, the public is unable to offer a meaningful and informed comment on the appropriateness of TCEQ's proposed agreed order. It also has an impact that this group is applying for a permit and is stating that they don't have the ability to pay the assessed fine. However, there are numerous non-compliance issues on site, and they're stating that they would have the ability to pay for those. The community would like to address these concerns and believes you have the jurisdiction because of the new facts and considerations given that this process was done improperly, inadequately, and inconsistently with the requirements of the statutes and rules within the commission's jurisdiction. Thank you for your time.
Thank you, Mr. Bates. Just for clarification, the period that you're referring to is that January 14, 2021 up to September 12th, 2022. Is that correct? Or Ms. Hammond might take that one.
That is what we understand from the executive summary, that TCEQ staff acknowledged that Texas Star Ready Mix took over the lease for this facility.
Okay.
There is no new authorization during that time frame, so they must have been operating in this exact same way. But again, that's conjecture because we were not able to obtain the operational logs from them through TCEQ, and TCEQ didn't obtain them either.
All right, thank you. I understand
you.
the point. Colleagues, any other questions for Ms. Hammond or Mr. Bates? Seeing none.
And we also have Hannah Asarabi for the respondent who would like to address the commission.
Okay.
And they're virtual, I believe.
Ms. Asarabi, go ahead, please.
Yeah, hi. Good morning, everyone. I would like to speak in behalf of Texas Star Ready Mix. I wanted to kind of confirm what Mike Bates and his Wendy was speaking about the Texas Star. They present a lot of false accusation, lies, and inaccurate information. The first part is the company took over lease in January. We had a few different permits and we were inspected by TCQ and the city of Dallas, and we were given the green light to work. We never been instructed by TCQ or the city of Dallas to hold with the first time of the visit of this saying our permit by rule does not satisfy everything. The company has existed since 1955 and had standard exemption. The company we took over in January of 22, but we were not operating at that time. And in September and August 9, 2023, the company halted patching and never patched it again. So there was no truth about anything operating after we advised TCQ. We voluntarily halted the operation. The other thing I want to refer to, both Wendy and Mike Bates keep referring to GFT Townhome Association. We never know which association is that, how many members. There's only one member for it. Who they are referring to? Who's this person who's referring this information with no proof? They're making false accusation over and over and over. And I don't understand even the only entity with that name, it does not even active. It's illegal. It does not even pay the franchise tax for the city or for the state. So I'm not sure who they are representing, to be honest. I feel they falsify this information with no basis. And I disagree. Yes, when the business is closed, how are we supposed to pay this high fine? And the only fine Texas Star had is this fine. There's no other fine. So they cannot come up and say there's multiple fines and multiple violations where there is none exist, beside in their own imagination. I do thank you for giving me the chance to speak. And if you have any question, I'll be glad to answer.
Thank you, Ms. Asarabi. Just so I'm clear, I thought I understood that you said that you have not operated at all since August 9th, 2023. Is that correct?
Correct, yes.
Okay. And when did you begin operating the
We
facility?
started the operation. We started the operation of July 2022, and we actually had talked to TCQ, do your small business. We have permit by rule. We have wastewater permit to batch concrete. We had the stormwater permit. We had for the gas tank, and we were told, since we have the wastewater permit, it's a general permit that allows us to operate and batch concrete under permit by rule. And we had another permit by rule for handling material. So we had different permission, and we were inspected by the Air Division in August, and we never at that year, and we were told we are good, and our permit by rule was working. It's an enforce.
Okay.
So I
understand.
don't know. Somebody made the accusation that we had change of use. We never had a change of use, and this is what it started. And we are in compliance. The moment TCQ said start applying for your permit, for your standard permit, we started that. We did the process, and we followed all the rules, and we followed everything. So we always try to be in compliance with the state, with TCQ.
Okay. Do you recall what day in July of 2022 you began operating?
We started July 2023. I'm sorry, 23rd.
July 23rd.
That's an approximate.
Approximately July 23rd, 2022, you began operating at that site, correct?
Yeah.
Okay. I don't have any other questions. Colleagues, any questions for Ms. Asarabi? Seeing none. All right. Thank you, ma'am. We appreciate your comments. Is there anybody else signed in to address the commission?
We have another representative from the facility who's available for questions, but didn't ask to address.
Okay. Why don't we do this? Why don't we offer executive director staff an opportunity to respond to anything that they have heard, and then we'll get to the Public Interest Council for their thoughts.
Good morning. This is Melissa Cordell. To address a couple of the items, there's going back to providing information. We did fulfill our obligation for the public information in providing public information. So we, any documentation that was considered to be confidential, such as that financial inability to pay information, that was not provided, but that was what was determined to be appropriate. In terms of operational logs, as indicated, they have ceased operating since August 2023. We do not have operational logs for that. And since we were also in an agreed order, we were working with this entity, they were providing us information that was required. We did not have those operational logs.
Okay, just to, let me pause there just to
Oh,
summarize. We produced the documents that were in our possession that were not confidential.
Correct.
This did not include operational logs because they are not in the agency's possession. Is that correct?
Correct.
Okay. This did not include certain information or maybe the entirety of the financial inability to pay analysis because we consider those confidential, and moreover, we requested the Attorney General to offer that office's opinion about whether they are indeed confidential or not.
Correct.
Okay. And if the Attorney General says they're confidential, we'll treat them as confidential. And if the Attorney General says they're not, then we'll produce them. Okay. So that addresses the Public Information Act piece, and you can go ahead.
In terms of assessing the penalty, we did follow our penalty policy, and we reviewed the criteria, as was mentioned before, in terms of culpability. We did review that. We did not determine that culpability was appropriate in this situation. We reviewed the time periods in which we assessed the violation. We were consistent with how we would typically determine the timeframes, and in this case, it was investigation was our start date. And that was in September of 2022.
All right. Thank you for that. Colleagues, why don't we gather Public Interest Council's thoughts and then we'll come back to discuss, or actually.
I have a question for
Commissioner Ginecka,
Ms.
you
Cordell.
have a question on the tip of your tongue. Go ahead, sir.
The investigation in September, to make sure I understand correctly, was the beginning of the date for this particular matter. Was the period of time from January 2023 that Ms. El-Sarabi mentioned earlier in her remarks, was that period that precede the window of time that the enforcement staff considered in this window, or is that new information that enforcement staff maybe weren't aware of? Or can you speak to that period of time where it's the September investigation marks the beginning of the time period in this order? What can you speak to that earlier stretch of time, please?
And I'm sorry, Commissioner Ginecka, help me out. You're talking about what dates, what time period?
I see in the screen for this item the September 12th, 2022 through November 3rd, 2022 time period described by our enforcement staff. And I hear from Ms. Cordell that there was an investigation in September that may have kicked off this matter. What do we think about the period of time from January through September? Is that going to be considered in compliance and enforcement ever? Do we consider that a closed matter? I'm hearing of allegations today and a date and time that precedes the date in this screen worksheet.
I understand that. Thank you. Ms. Cordell, do you understand? I'll give you a moment to organize your thoughts on that.
Good morning. For the record, my name is Amy Sedemeyer with the Enforcement Division. If I'm understanding correctly, the question, I think we did address the time period from January to September of 2023, in that there was a subsequent investigation done by our regional office in August of 2023. And so both of those investigations are rolled into the penalty considerations for this order. It was the whole period from 2022 to 2023.
Commissioner Ginecca, did you understand
Does that,
that?
I believe I follow, and there's a lengthy document associated with this order, this filing. So perhaps you might be able to direct me later to where that earlier period of time may be discussed in a compliance screening worksheet in this in the set of records. But do I understand then that we did include the period of time that incorporates and includes the date from July 2023 through the September 2023 window of their alleged operation in this order before us today?
Hold on a second. Let me try to clear some things up, because I think some of the dates are being miscited. This enforcement order pertains to the period September 12, 2022 until August 9, 2023, correct?
that's correct, Chairman.
Okay. And we heard the respondent testify that all operations ceased and have not resumed since August 9th, 2023. So
That is correct.
okay. So that was her testimony. So that evidence suggests that there is not a continuing violation for operating without a permit. You can draw that conclusion from that evidence. If different evidence arises, we'll consider that when it arrives, but that would not be part of the matter that's before us today. I think the question is, what about the time before September 12, 2022? Not part of the matter before us, should it be? Commenters pointed to a January 2022 lease date. I think I've got that correct. And the respondent admitted to beginning operation in July of 2022. So based on the respondent's own admission, this item, and I understand that it's consistent with our practice to focus on the dates that we can prove up by our own investigation. That's what we have evidence for. We have new evidence this morning from the respondent herself that the violation actually began in July of 2022. So Commissioner Ginecca, I don't want to put words in your mouth, but was your question about that time period before the time period that's the subject of this enforcement matter, September 2022?
Thank you. Very well translated.
Okay. I'm glad that was well translated. I wasn't sure that it was, but back to Executive Director Staff, Ms. Sedemeier, Ms. Cordell, what do we do about those days before September 12, 2022?
I'll take an initial stab and then I'll let Ms. Cordell fill in if I missed anything.
Okay.
So you're right, our standard practice is to base it on the date that our investigators went into the field and documented the violation. This particular case did have discussions on the permitting aspect and what was required and what was not required based on the timeline. And so that was cleared up through that investigation. And so that was part of what we went through, the investigation, the region and the local area program, trying to determine what permits were required. And it wasn't until that investigation that it became clear that they were operating without the proper authorization. Anything else on the actual lease?
Well, okay. So, and apologies for potentially restating a little bit also, it is our practice to begin the penalty assessment from the date of the investigation. We could have assessed it from the date of the operations began. However, we don't believe that we actually had that information at the time. There were 2 violations in the case from September to November and from November to August. We may not have had the documentation demonstrating that they were operating without authorization prior to that September 12th, 2022. And even if we do assess a penalty for that, acknowledging too that there is a FIP analysis that was underway. So just in consideration of that as well. So, okay.
Okay. So your last comment was, practically speaking, if we accept the financial inability to pay demonstration, there would be no or maybe no difference in the ultimate amount of the penalty.
I would say maybe no.
Maybe.
I don't know that we
Okay.
could know with certainty that there wouldn't be a difference, but
Okay.
because of the financial inability to
All
pay
right, I
analysis.
appreciate that.
Yeah.
Thank you, Ms. Sedemeyer and Ms. Cordell. All right, I don't see questions on the lips of my colleagues, so why don't we have you, Mr. Arthur, share Public Interest Council's views on the entirety of the docket, but specifically on 9 as well.
Thank you, Chairman. We did consider each of these enforcement items, and I'll take this moment to comment on item 9 regarding Texas Star Ready Mix. To start, we reviewed and appreciate the public comments on behalf of the Joppa Freedmen's Town Association. OPIC notes that respondent applied for the required authorization on January 30th, 2023, but continued to operate without authorization until August 9th, 2023. Given the intervening time, we question whether there should have been at least some culpability for the delayed shutdown. However, OPIC also recognizes respondents' financial inability to pay a larger penalty. And further, we acknowledge the greater importance of bringing respondent into compliance. We therefore support adoption of all the enforcement orders presented by ED staff, including item 9.
Thank you, Mr. Arthur. And colleagues, Ms. Asarabe has requested to address this again. So Ms. Asarabe, we'll give you some more time for that now. Are you there?
Yes, thank you.
Go
Thank
ahead,
you. I
ma'am.
want to just clarify, we were told we have different permit to patch concrete. There was no intention or bad intention to operate without a permit. When we told we have all the proper permitting, when we started the operation in July 23rd, 22, and when the staff came and talked to us about the violation, nobody instructed us in the exit form to close or told us we cannot operate any further. We would have respected that as well. And the moment they told us, we followed, we tried to comply every way with TCQ, worked closely with it to make sure we are doing everything correctly and within the law. Thank you.
All right. Thank you, ma'am. Bear with me, colleagues. All right, we've heard from the parties. We've heard from interested persons. What are your thoughts? Commissioner Ginecca?
I appreciate OPIC's position on this, and I think I'm generally in agreement. Today, I was prepared to move forward with the order before us. Generally, on all the items before us, but speaking specifically on item 9, I think frankly, I'm a little concerned from the comments I heard from Ms. Al-Sarabi, where she's questioning who her neighbors are. I appreciate that having the comments that are critical of your site and operations coming in under the title of a group gives you room to question who are the members of the group, but these are your neighbors. And I have serious concerns when I feel that that's the posture that you're going to take with responding to concerns of your neighbors, because we're being asked to move forward with this order today, which significantly reduces the amount of the penalty you will owe the state. And that penalty is then due if you do not continue to follow our agency's requirements and obligations and return to compliance. But that said, I think the fact that you did voluntarily cease operations, the fact that you I believe that you did operate under the understanding that you were able to operate. I don't think that I had the impression today that you were that there was a culpability issue, but I do have real concerns where I hear one of our regulated entities responding with such defensiveness to one of their neighbors. That said, I'm comfortable moving forward today and don't have any other particular outstanding questions.
Thank you, Commissioner. Commissioner Gonzalez, your thoughts?
I'm prepared to move forward with the orders.
Okay. All right. Well, I'm prepared to move forward with the entirety of the docket except this item 9. I think I'm inclined to remand this to the executive director so that the executive director can determine what effect the additional period of non-compliance that was admitted to this morning may have on the penalty. Yeah, I think it's likely that it will be trivial or no effect at all, but let's find out what that is. I would also say that would give us an opportunity to double check our work on the culpability question. And that would be my recommendation, but I heard both of you suggest a different result. So can I pull either of you over to my side to remand this matter for the reasons I just expressed?
I could support you on that. I agree with you. I don't think it's going to change anything. I think the financial inability to pay is what it is.
Yeah. All right. That's 2. That's all I need, Commissioner Ginecca, but
Let's make it unanimous. Thank you. I'm in agreement.
thank you. Okay. So I'll offer a motion in just a moment to go ahead and adopt the entirety of the docket except for this item 9, which will remand. And I do want to say that with respect to the pending permit application, that matters not before us this morning, but certainly all of the compliance activity at this facility informs that decision and that analysis. I think I'll just leave it at that and go ahead and offer a motion. Colleagues, I move that we adopt item 8 and items 10 through 28 as recommended by the executive director, and that we remand item 9 to the executive director for further case development.
I'll second it.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, please call the next item.
Item number 29 is the consideration of the monthly enforcement report, and the executive director's staff is here to present this matter.
Good morning again.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Amy Sedemeyer of the Enforcement Division, and with me are Melissa Cordell of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2024 through March. There were 362 effective administrative orders issued, and of those, 64 contained supplemental environmental projects. These orders assessed a total of $6,800,166 with a payable amount of $3,088,193. $3,112,019 are to be paid towards supplemental environmental projects. 8,472 notices of violation have been issued either through our field offices or review of self-reported data in our central office, and 1,075 enforcement action referrals have been received. There are 3,084 pending administrative orders with 1,710 cases that are on the backlog, which does reflect a small decrease from last month's report. 169 cases are pending at the Attorney General's office for representation in district court, and 5 judgments have been issued. 1,535 cases are being tracked for compliance. We're available to answer any questions you may have.
Thank you, Ms. Sedemeyer. I have none. Colleagues, any questions? Seeing none. Ms. Smith, is anybody signed in to speak?
No one has signed in on this one.
Mr. Arthur?
OPIC has no comment except to say that we appreciate the report.
Likewise. Colleagues, any thoughts, comments? Seeing none?
Oh, I have.
Oh yeah.
I just
Commissioner
wanted
Gonzalez.
to say a quick thanks to everyone who participated in Trade Fair. I thought it went really well, and the Environmental Excellence Awards were excellent, of course.
Agreed.
Yeah, and
Thank you.
congrats to all the winners.
Thank you for that. Commissioner Janeka.
Appreciate the report. I'm very glad to see the backlog decrease. Hope that we see a future trend, but always eager to have further discussions with enforcement as you work on what our prior discussion on the previous docket shows is always very complicated issues.
Thank you, Commissioner, and thank you for the report. And no action is necessary on this item. So Ms. Smith, I'll ask you to please call the next items.
Items 30 through 33 are for closed session, and the commission will not be meeting in closed session today.
Time is 11:09. We are adjourned.